Good morning, everyone, and welcome. My name is Tracy Winter. I'm an attorney, and a lot of my practice is based on estate planning. And estate planning just entails wills, living wills, dual power of attorney, and I'm going to go into that. So I'm not sure if you guys saw my bio in the newsletter. My background is, my mother, even though it's been over 20 years since graduating, she said, let them know where you went to school. So I went to Princeton for undergrad and then Temple for law school, and I've been practicing since 2005. So this topic is how do I let my loved ones know what I want in terms of my estate when I pass on. But it's also not just when you pass on, but also if there is an illness. So we're going to get into that. So how do you let them know what you want? You have to tell them, but not just in a conversation. You have to do so legally as well, in a formal way, in writing. So there are different documents, and I'm going to touch on 4 very important documents. That's the last will and testament, the living will, and the designation of a healthcare surrogate, and a durable power of attorney. And also, and I mentioned this, I believe, in the bio, I'm going to talk about ways you can also just save money as well in terms of estate planning. And if you do see a lawyer, things that you can say, well, why should I do that if I can do this way, and it's simpler and cheaper? All right, so what are these 4 documents? So you've got your last will and testament, which is just a legal declaration where you appoint someone to manage your estate for you. In the state of Florida, we call it a personal representative. Other states will call them the executor. And then in this last will and testament, you state who you want your beneficiaries to be. Pretty straightforward. The living will, this allows the person to explain in writing which medical treatments they do or do not want. And a designation of healthcare surrogate allows you to appoint someone to make healthcare decisions for you. I'll go into detail on that because it doesn't necessarily have to be right now. It can be if you lose your mental capacity. And your dual power of attorney is a document where you're pretty much saying, I'm allowing this person to step into my shoes and sign anything I would sign. It sounds scary, but it's actually can be very helpful if you have a trusted person or trusted people in your life.
Sorry, I'm late.
That's okay. Let's get started. All right, so last will and testament, like I said, legal declaration. You're saying, I'm leaving my assets to these people or to this person, and I'm appointing this person to manage that. You have to be in Florida, at least 18 and of sound mind. And I always say, most people don't know an 18-year-old who is of sound mind. Is that why you're laughing, Carol? And the formalities have to be, you have to have 2 witnesses, and there's a form where you have to actually have it notarized. Not all states have that notarization part. So a lot of people, when they do wills on their own, they tend to mess up in the formalities because they'll grab a notary and they'll grab someone else to be a witness. And they'll have the notary be a witness. And you cannot be a witness in the will because the notary has to take the oath of the 2 witnesses. And a notary cannot take their own oath. That's the self-proving affidavit part. So what that is at the end of the will, the person who signed the will, say it's the testator and the 2 witnesses, they sign an affidavit saying that they were all present for the signing. So that's a self-proving affidavit. Not all states have that. So I have a lot of people who move from other states and they'll say, my will is bad, I need to do another will. And that's not necessarily the case. So if you have a will from another state that doesn't have that self-proving affidavit, it's not bad. However, if that will has to be submitted to probate and you have to go through the court process, then you have to then find one of those witnesses who signed the will as a witness. And you can go back, one time I had to go back decades. I had a will one time where the will was signed in the 70s, and it was from New York, and there was no self-proving affidavit. And I said to the lady, the will's not bad, but we have to locate one of these witnesses. And she said, they're long dead. She said, this will is like 40 years old. So I was actually able to track down one of the witnesses. He was still working as a judge part-time. I'm not sure if he was really working, or they just, they had him doing something twice a week to come in. But he was good morning. But he was very helpful. Like, he was very excited to sign this and say, yes, I was present for the signing. So he was in his 90s. I was able to track him down for about 35, 40 years. So I also want to make very clear that a lot of times people will get a will and they think that they don't need to go through probate or estate administration of What that means when people say, I don't want to go through probate, it's having to prove the validity of your will in court. So even if you don't have a will, you still need to go through probate, but the technical term, or the better way to say it, is an estate administration, meaning having to go through the court process. So people think I have a will, I don't need to go through the court process because my will says I want my kids to get everything. But that's not the case, and I'll give you an example why that wouldn't be the case. Say you have a bank, John Smith has an account at Bank of America, and he's not married, and he's the only one on the account, and he's leaving everything to his daughter, Jane Smith. John Smith passes away, and he has no beneficiary named to his account. Jane Smith cannot go to Bank of America with the will and say, this is my father, he passed away, he's leaving everything to me. Because Bank of America is gonna say, well, I don't know if this will is valid. I don't know if if you produce this, I need a court order. So a will does not mean you can bypass going through court. Does that make sense? So an advantage to a will, very obvious, allows you to distribute property to your family, friends, or charity of your own choice, rather than it being distributed by operation of law. And what I mean by operation of law is if you pass away without a will, that means you pass away intestate, meaning no will. And the laws of the state where you pass away, where you're resident of, actually where you're resident of, not where you passed away, the laws of the state where you're resident of will dictate how your assets are to go. So say you are a single person and you don't have any children and both of your parents are deceased. So the way the law goes, if you pass away as a single person, they see if you have any children, so it goes down the tree. If you don't have any children, it goes up the tree to your parents. If your parents are deceased, then it goes to your siblings. Now, say you haven't talked to your siblings in ages. The law is going to say, well, it's going to go to your siblings because you don't have a will. So a will is good if you want to make certain that certain people get your assets. Also, it allows you to appoint people you trust to execute your last wishes. So a lot of times, I shouldn't say a lot of times, but sometimes people have kids, let's say they have 3 of them, 2 of them are wonderful, 1 may not be as wonderful. So if you have a will, you could say, I want this child to be my personal representative, and if something were to happen, then I want my second child to be the successor personal representative. And it's a way so that third one doesn't come in and say, well, maybe mom would want me to be the personal representative. And that's not the case because it's in the will who they want to be the personal representative. All right, so a will protects your loved ones in their time of need, especially if you're not married and in a long-term relationship. So I wanted to throw this in here because I one time had a lady who was dating someone for 25 years and they hadn't gotten married, and he suddenly passed away. And she was not on anything. They had 2 houses. Well, he had 2 houses. He was on everything, she was on nothing. So he had 2 houses. I think they had a small account together. And the other house was in another state. It was the other state and here. And I was talking with her. He took care of everything too. So I said, well, where was he a resident? We're trying to figure out what state it makes sense to do the probate in. And she said, well, I don't know. We're residents of. So I said, where'd you vote? We didn't vote. Where's his license? And she didn't know. I mean, she was really just lost without him. So it turned out in that situation, there were no kids, so it didn't go down the tree. His parents were deceased, so it didn't go up the tree, so it went to his siblings. And his siblings could have easily said to her, we want you out of the house, because she was living in, going back and forth between these 2 houses. But they said she can choose whichever house she wants, and we'll take the other house, because that's what our brother would have wanted. But she got lucky. A lot of people wouldn't have done that. Whereas if he had a will, he could have actually said, say Jane Smith, I keep going back to Jane Smith. I want Jane Smith, my girlfriend, to get this house, everything else can go to my brother, or he could just left everything to her. But she was pretty much at the mercy of his siblings, who luckily were kind to her. All right, so having a will is a great way to prevent family disputes and legal battles in the long run, especially if you're not naming certain relatives. And I say this because in the state of Florida, say you have, and this is the example, I said having multiple children but only naming some as beneficiaries. I had a client one time, she was Miss Sassy. She was about 88 years old, super sharp, very with it and very sassy. And she started off the appointment with me saying, I got 5 kids, I don't like 3 of them. So I'm leaving everything to the 2 and to charity. And I said, okay, that's what you want. And it's funny, a lot of people are afraid to say that to me because they think I'm gonna judge them. It's like, I don't know your family dynamics, so I'm not gonna judge you. So by saying that you're not going to name them, they're not interested parties. So what I would often do is I name all the kids, and I say I'm intentionally not naming these 3 as beneficiaries. Because a lot of times people will tell me, I'll just leave them $1. You know, the ones who I don't want, leave them $1. I never do that because you make them an interested party. And I've read other articles too by other lawyers, and they say they believe then you actually have to track down those kids and give them $1. Why bother with that? Just say you're intentionally not leaving anything to them. And so if you're not leaving anything to them and they're not interested parties, you don't even have to contact them when you do the probate. You just contact the 2 kids and the charity in that example I was giving, and it makes life a lot simpler. Okay, so what happens when someone does not have a will? It's not necessary, as I mentioned, to have a will, to have your estate administered. It would just, sorry, that's okay. It would just be the laws of that state controlling. So instead of you making decisions, it's the law of the state controlling. And sometimes everything works out well. So if you are, say you're married, and all your children are also your spouse's children, most couples own everything as husband and wife, so everything automatically goes to the surviving spouse anyway without the need for probate. But say a spouse has something just in their name, they would have to do probate for that, but everything would go to the surviving spouse. And then if that surviving spouse passes away, then everything would go down to the kids in equal share. So it worked out fine anyway. It usually works out the way they would have wanted it to work out if they had done a will. And then other times, squabbling happens. And when people fight, I usually tell people the only one who makes out are the attorneys because we collect more money because you're fighting, it takes longer. I had heirs who were fighting one time, and a probate that should have taken maybe a month and cost me about $2,000, took 2 years, and was about $10,000. And that's just $10,000 less for the family and more for the attorney, so it doesn't make any sense. It's an example of dying without a will. So Prince, or the artist formerly known as Prince, he passed away, and he didn't have a will. I'm not sure if you guys can see this number down here. His estate was valued at $156 million, and he didn't have a will. Oh. And not even a will. Usually when it gets to be that high, you have a trust to kind of shield you from certain tax implications, but there was nothing. And when he died, he didn't have any children. He was not married. His parents were deceased, so then it goes to his siblings. And siblings were jumping out of the woodwork. Like, people were saying, I'm Prince's sibling, I'm Prince's sibling. So they finally settled on 6 half-siblings as his heirs. And there were several years of fighting over his estate. 3 of the heirs actually sold their interest to Primary Wave, which is an independent music publisher, and then the other 3 kept their interest. But if he had a trust or will directing how he wants his estate, so his assets to go, it would be less fighting, so less money for the attorneys, and more money going to where he would have wanted it to go. Okay, what about the will forms people can do on their own without an attorney? Typically they can get the job done, but it's in how people sign them. People, and I mentioned it before about the witnesses and the notary, so you have to make certain that you sign with the proper formalities, especially of the state that you're in. Usually Florida is fairly formal, so if you get a form that has Florida formalities, you're probably fine if you were to go someplace else. But if you were to see an attorney, they usually they should have the right formality that you need to use. Because when you make a mistake preparing the will, it's trying to save money in the beginning. Usually costs you money in the long run. Costs your estate money in the long run, because then that's when your family has to try to fix the mistake. And if you're gone, you can't fix the mistake, so the family has to try to fix the mistake. I one time it was kind of long and involved and complicated, but I worked with a will one time where the gentleman was in prison and he wrote his will from prison, and he was mad at the world. It was actually pretty funny, the will. Like, he actually said, I'm leaving Mary 2 cents because that's all she ever gave anyone. And they just went downhill from there. So if you do choose to use one of those forms, just make certain that the language is clear and precise, because ambiguity could tear a family apart. So misperception is that wills do not have to be complicated. I've talked to people like, oh, that's too much. I don't want to deal with it. It's too complicated. And it's not. It doesn't have to be complicated. Most of my wills that I do, they're about 4 to 5 pages long. About a page and a half of that is just signatures, so it's not long at all. Wills are not also, they're not just for rich people. If anything, I think people who are not rich benefit more because you save what assets you have for your family. So I have an example here. I was contacted years ago by a real estate agent who wanted to purchase property. This was a vacant lot, and the lot was worth about $50,000, and it was co-owned by this man and this woman. They were boyfriend and girlfriend at the time when they got it, they broke up. And the girlfriend was willing to sell her share to this real estate agent, and so she wanted me to find out what we could do for the boyfriend share. So when I was talking to the girlfriend, I said, well, where's your, what happened to the boyfriend? She said, she knew where he was because he was running from the law. Her word quote, running from the law, and he had several children, and he was deceased. So she didn't know about where his kids were, she didn't know, where he died. It just didn't make sense to go forward with it because he had several children, he was deceased, the lot was worth about $50,000. If it was worth $50 million, it would make sense to try to track him down, but $50,000 doesn't make any sense. So it can help, so again, not just for rich people, because if they had a will, so say he had a will saying, if I die, my share in this lot goes to my girlfriend, she would have easily sold it and made some money. All right, so recommendation, see an attorney, and I should say this, I'm not trying to sell my services. This is really just general information, so I'm not trying to sell myself here. So see an attorney to get a will, and also, not all assets have to be transferred by will. I do a lot of this with my clients about financial accounts. You can set up beneficiaries because when you have a beneficiary on an account, it bypasses the will. So going back to the example I gave of John Smith at Bank of America. So if John Smith had named his daughter Jane Smith as a beneficiary to his account and set up as being payable in death or transferable in death, and some banks like Trustco will say in trust for and have a beneficiary named, then that bypasses the will, and the only thing Jane Smith would have to do is show up with a death certificate and proof, death certificate that John Smith passed away, and proof that she is Jane Smith, and the bank will just give her the funds, or she won't need to get a court order. Also, there are types of deeds that you can do to transfer real property as well. So there are different types of ownership that you can do, but a deed that I do often for clients is called an enhanced life estate deed, or it's also called a ladybird deed. And I do a lot for my clients, especially my clients who are perhaps may need to go into a nursing home in the next few years. That really happens, but just in case it happens, it's where someone conveys a life estate to themselves and they retain all the right to do whatever they want with the property, so they can sell it, mortgage it, lease it. And then upon their passing, it goes to whoever their name, so it'd be their children. And by doing that, the property bypasses probate as well, because you very clearly state who you want to get your house. And the reason why I do it for my clients who may need to go into a nursing home soon is because to qualify for Medicaid, you can't look as though you're trying to give away your assets. So if you just give your house to your kids, you're going to create a big penalty period for yourself. So when you do this type of deed, you're retaining all the rights that you want with it. You're just saying, upon my passing, it goes to this person. So you do not create a penalty period. So a lot of Medicaid estate planning attorneys will do an enhanced life estate deed or a ladybird deed.
I would just say, first of all, I'm not buying Tracy's services because I've already bought them. But I was a geriatric care manager in California, and I didn't know about the Ladybird Trust.
Not all states do it.
I know, and so trying to figure out how to protect assets from Medicaid, that's usually a huge expensive project. But the Ladybird Trust was wonderful.
Yeah. I would say Florida, so I did a little bit of Medicaid estate planning years ago. Florida's pretty liberal with what they allow in terms of the Medicaid estate planning. I think just when you look at the population and demographics, it makes sense to be that way. So what they say is you're allowed $2,000 worth of assets, and most people have more than $2,000 worth of assets, but they don't count your house, so your primary residence doesn't count. If you have 100 rental properties, and granted, I haven't done, so this is information circa a few years ago, so they may have updated it. So if you have rental property, like say you have 50 rental properties, they don't count that as an asset, but they will count your rental income. So you have to look at it as asset and income. So you're only allowed $2,000 worth of assets, but you can make a lot of your assets non-countable assets, and you're only allowed a certain amount of income, but you can create a trust so that your income goes into that trust. It's a process, unless you think that there's a concern about needing to go into a nursing home. Most of my clients, at least, don't worry about that, unless there's been maybe a diagnosis of, early Alzheimer's, early dementia. So if you already have a will, you want to make certain you keep it in a fire and flood-proof safe. I was looking at someone on Facebook. She just lives here in Kissimmee. Her house is totally flooded out, which is from the storm, which just blows my mind because not as if it's that far, but she must live on a lake or something. So you want to make certain that you keep your important papers in a fireproof and a flood-proof safe. Some people keep their important papers in a safe deposit box at the bank, which is fine, but you want to make certain that that you have at least two of you on the safe deposit box so that someone can access it. And I'll say, so we have my mother actually has a safe deposit box, and she has me on it, but we travel together. So we wanted to put my brother on it because he's not here. And, he's not traveling with us, but the bank says we can only allow two of you on it, which is a bit of a pain. So you may want to have, depending on the situation, if your bank allows more than two people, get that, a child or someone you trust, because what happens is after you pass away, the person is going to have to go through court to be allowed, because the bank's not going to allow you to access or allow your loved one to access it without some sort of court order saying that they have authority to access it. Does that make sense? Yeah. What's that?
What you said makes sense, but the fact doesn't make sense.
All right, so beneficiary designations, I've talked about them. I think they're wonderful to have because you can very clearly state if you want to have your assets. You could do this without an attorney, so it's something free. The financial institutions don't charge you for it. Do it on your, your life insurance, your investments. You can do TD Ameritrade, all that stuff. You can put beneficiaries on it. Something that I saw recently was with Red Fox is you want to make certain that if there's been a divorce or just a life change, that you change your beneficiary designation. Because Red Fox, when he died, he was married to wife number 4, but he still had wife number 2 named as the beneficiary on his life insurance, and they fought over it, and wife number 2 won, even though he was married to wife number 4. Now, in the state of Florida, that wouldn't be the case because former spouses are voided. So if you are married, you name your spouse, and you get divorced, as a beneficiary, you get divorced, Florida will say, okay, we're voiding that spouse, or we're treating it almost as if that spouse passed away. Like it's not going to be an issue. Unless there's a divorce decree that says that that spouse remains the beneficiary, especially if they're kids, for the support for the kids. All right, we're moving on to living.
I might say one thing on the accounts being payable. You can add your children, your adult children, as beneficiaries in your checking and savings accounts, and that multiplies your $100,000 FDIC insurance per each one. Each one gets $100,000 as a beneficiary. Okay, we found that out a couple of years ago, so we had a lot of cash in the bank, so we put all 3 of our sons as beneficiaries on the accounts, and that multiplies it by 3. So we now have.
It's protected, in other words.
It protects.
Instead of 100,000, it'll be.
It's protected at 400,000 by the FDIC. Didn't even know that. Just
Yeah, that news to me too. Thank you.
yeah.
So do you want questions at the end?
If you can ask questions.
I'm sorry.
Well, I
that's
was
fine.
wondering about, so if Florida's gonna distribute your assets exactly the same way you would, is there an advantage to a will then?
So I actually will tell my clients, no, there isn't, unless you want to make certain that there's a certain person doing the distribution, naming the person representative. So if you have 3 kids and you trust one of them a bit more you trust them a bit more to handle the distribution a bit better than maybe the other 2, you may want to get a will for that and say that. But if you trust them all 3 and you know that they're just going to divide it equally, then I've actually told clients it really doesn't make sense to have that extra expense to have a will. Like that lady who I mentioned who had the 5 kids and was disowning 3 of them. It makes sense for her to get a will, but if you're gonna if the law is such that you're gonna just give it to all your kids anyway.
Right.
And you wanna make certain that all your kids, so this is something that's really important. So all your kids actually have to be the spouse of your kids as well. So if there was any other child out there, it changes the distribution of how the law would be. And what I mean by that, so say you're married for 40, so I had a client one time, I was talking to them, the husband was clearly much older than the wife, and they had kids in their 20s. He was in his late 60s, she was in her 40s, and I said, so the kids, you just talking about the 2 sons, that's all you have, right? And he said, yeah, that's all we have. And at the very end, when I said, okay, have a nice meeting you, they said, oh, I have 3 daughters from a previous marriage. And I said, okay, that changes. But they were much older, so he was thinking they wouldn't need assistance. So in a situation like that, the laws change because the laws would say that if they're not the child of your spouse, then they also are entitled to something too, if you die without a will. Does that make sense? Okay.
I have a question. My daughter has remarried, he has 2 children. So we want our daughter to get what we leave her plus her children, rather than given to him so that he would split it with his children and our grandchildren. You know what I mean?
Would that be automatic?
So what you're saying is you want everything to go to your daughter
And
her children?
Yeah, rather than given to him and then split between his children and our children and our grandchildren. You know what I mean?
Well, so the way it would work is she adopted?
No,
Okay.
I mean, they're a blended family. I don't think either of them adopted the other, you know.
Okay. The reason I was saying is adopted, because adopted children are treated as biological children.
Okay.
But stepchildren actually don't have rights.
Okay.
But if you are concerned about that, then you can make that very clear in a will.
Yeah.
That states that, if my daughter predeceases me, then, or I'm not sure if it was predeceased, or if you just want to split it between your daughter and your grandkids, then you can just make that very clear that your goal is, not your goal, but your desire is that it's your daughter and your grandchildren.
Okay.
He wants your son-in-law cut out, is what you're saying.
Well, I know, I don't mind if he gets it, but I don't want his kids to get it. You know what I mean?
Yeah.
To go down. Yeah.
They have other parents and they.
Sure, they're gonna be getting it from
Yeah.
that, yeah.
Makes a lot of
She
sense.
doesn't need a reason. So we're not asking for reasons.
So when you talk about kids, say one child is married, has children of his own, the other one is not. If you don't have a will, how would they distribute the money if there's a single child, a married child, a spouse, and grandchildren?
3 kids.
Yeah, it still goes to the kids. So even though, so say you have the kids, so say one child is married, one child's not married, it still goes 50-50 to the 2 kids.
To those 2 kids?
Yeah.
So the extended family of the one doesn't take a bigger share?
No. So if you had a child who passed away, like was deceased when you passed away, then you can have language that says you want their 50% to be distributed amongst, say they had 3 kids, amongst their 3 kids. Does that make, you know what I mean?
Otherwise, it would all go to the other kid if you only had 2 kids to start with.
Well, you have to make, then it will go to this, no, actually that's not true, then it would still go down, but a lot of people prefer just to say that it goes to the surviving child, and then they have the surviving child, this is a lot of my clients, I want to do it this way, and the surviving child would then distribute amongst the kids. Oh, right.
Yeah, I'm sorry, I'm gonna kind of move on here, but this beneficiary thing, so I actually have a meeting with our family attorney at 2 o'clock on Wednesday on this very subject. So our wishes are, when both my wife and I pass away, we want a certain percent to go to some Christian ministries, and then the rest divided equally amongst our 2 kids. If we put a name in, the Fidelity investment account and the bank account and all that stuff, that bypasses the will and it distorts that division, that equal division amongst the kids. What in the world are we supposed to put in the beneficiary fields that the bank keeps screaming at me that I don't have anything in there?
You mean for the charity that you want to put in?
No.
I didn't follow you then.
So your bank and your investment accounts, they want you to put something in the beneficiary, the 2 names. You got 2 slots there, put 2 names, right? If we put a name in there, then that conflicts with what's in the will.
No, so when you put a beneficiary in, that bypasses the will.
Yeah, so then I want to put nothing in there, or do I say, see the will?
So if your goal, and they're only allowing you 2 slots, is that what you're saying?
Yeah.
That's interesting. You should
You
be able
got
to put
three?
as many, you should be able to put as many as you want.
Yeah.
I think you should go back to the bank and talk to a manager, because I've never heard of someone being.
Well, but even if you put any name in there, I mean, you know, the dollar amounts, you're moving stuff between accounts and all that, so if I put any combination of my kids' names in the beneficiary fields, it's gonna distort that equal split of on debt. It's gonna distort the equal split.
On
Why?
that account.
Are you talking about the whole of your entire estate? Yeah, so if you put, so if you have, so just say Bank of America again, if you put your 2 kids in, they get 50-50 as beneficiaries.
I don't want them to get 50-50.
Okay, then you have to do it in your will.
Okay,
Unless your
so-
bank is willing to do it, and I haven't met a bank that's
So
willing
then
to do
what
that.
do I put in that beneficiary name field?
Zero.
Yeah, nothing, because then you want it to go pursuant to your will, then you wouldn't put anything in it.
Okay.
But I haven't met a bank that's willing to not have it equal. So you could see if they're, you know, when I say not have it equal, like, you know, 70-30, you could see if your bank's willing to do that, but I haven't seen that. If, for a bank, maybe investments might be able to. I think life insurance you should be able to as well. I've seen that. So maybe you wanna put the money someplace else where they'll allow you to do that, if that's a major issue for you.
All right,
All right, so we're good?
well, I want the will to dominate, that's what I want.
Then don't put anything in the beneficiary.
All right, thank you.
You're welcome. All right, next one is the
You saved me,
living.
you saved me 2 hours of attorney.
Still should say your attorney. All right, living will. So it just states whether or not you want to be artificially maintained. If you're an internal condition, an end state condition, or a persistent vegetative state. Now, the majority of my clients say they do not want to be artificially maintained, and they say, you know, I just want to make certain that my family knows that. I usually say, I want them to pull the plug, that's really what they tell me. So advantages, clearly it allows you to refuse treatments that you do not want. You know the outcome. It prevents arguments among your family members, because sometimes, you know, one child may want one thing, another child may want another thing, so then they fight over that. Whereas if you have it in writing about, you know, if I'm ever in a, you know, end state condition, you know, I don't want to be artificially maintained, it's very clear. Again, makes decisions easy for your family.
Can I interject something else? Have you ever heard of 5 wishes?
No.
Okay, it's a pamphlet that comes out. I'll try to bring one next week when I come, and it's a pamphlet, and it has your 5 wishes, okay? And it tells your kids what you want done in these particular situations. And you put it in writing, it takes you an hour, 2 hours to fill it out, and it's fabulous. Has anybody else heard of 5 wishes?
Who produces it?
I've got it at home. I was looking at it just the other day in our will. It's right with our will, and it's really great, because when they open that will up, there's that 5 wishes document, and they will know exactly what we wanted done with that
Which
money.
is pretty much
It's
the
not
same.
legally binding.
It's,
Yeah.
Or maybe what you want in a funeral, what you want.
yeah,
Yeah.
it has
But the
5
living-
areas. I don't-
But the living will starts before you're dead.
Yes, oh yeah.
Living-
Awesome.
They ain't looking for the will yet, okay? They're trying to see how you're gonna live. And also, in case you're not gonna say it, is a do not resuscitate, a DNR
Yeah, she
order
wasn't
that
going to.
that has nothing to do with the living will. And so having a DNR does not mean you have a living will.
Correct, yeah, because I actually don't prepare DNRs because of the hospital.
How about living trust? Is that different than living
A
well?
revocable living trust or irrevocable living trust is totally different than a living will. I do touch on trust at the very end. So we'll talk about that.
On the do not resuscitate, I have one on my refrigerator in my wallet. I have some autoimmune diseases, so I don't want to be resuscitated. But I wear this, and I was thinking of having it tattooed here. Because the paramedics will do anything, you know, that's their job. And so you have to be really, really clear. And with your family, because they'll start to waver. I don't want to let mom go. Well,
Yeah.
mom doesn't want to stay in this condition.
Yeah.
So it's a delicate thing, and it's also your own personal preference. Some
Exactly.
people want to fight, you know,
Yeah.
I don't.
Well, I know brothers who, the older brother was not named, and actually I'm jumping ahead a bit. As a healthcare surrogate, that's the one who can make healthcare decisions for you. Again, I'm jumping ahead. The older brother was not named that. The younger brother was, because the father knew that the younger brother would listen to his wishes, because the father did not want to be artificially maintained, whereas he knew that the older brother would do anything and probably keep dad on life support artificially for 50 years if he could. And that wasn't, father's choice.
How does this relate to what Terry Schiavo experienced?
Oh, we're gonna talk about
Are
that.
you getting there?
Yeah.
I'll wait.
One further thing about 5 wishes. Think of it as a living will or as a conversation piece you can use. 5 wishes is a legal document in all states except for 8. It is a legal document in the state of Florida. So we fill it out. We even had ours notarized.
But we got it with our will.
And we got it with our will, but it's a living will, and that tells, we don't want we won't have a DNR, we have all that. But, sorry.
No, thank you. I need to look that up. I've never.
Yeah,
I'll look at those
it says it's been around. Just Google, it's 5wishes.org.
All right, so advantages again, ensures your doctors follow your wishes, authorizes treatments you may want to have, and eliminates financial encumbrance for your family. I just mentioned how the older brother would probably try to keep dad around for 50 years. That's obviously a cost. So what about living will forms you can obtain without an attorney? They typically get the job done. And when people come to me for estate planning, and this is one of the documents we discussed, I'm very upfront and I tell them you can actually get it at the hospital. Like most hospitals just hand them out for free. So if you go to Celebration, I actually was with a client one time years ago. We just walked to the front desk and they give them out. Also, if you had a procedure, you may have already signed one. So many moons ago, my mother had a procedure done and she was groggy and they just, slipped it in front of her. I mean, I had her sign it. So you may have one already.
Do they live forever? Like if you signed one at the hospital, would anybody find it? Or do you have to have one with you or?
You should get a copy of that. You should definitely get a copy of it.
They put them in your medical records also.
Yeah. You guys are so good. You're touching on things I'm going to be touching on. All right. So again, what happens when there's no living will? The family's squabbling, family members making decisions, they may question whether or not they're making the right decision. So an example of that is a pastor who's since passed away, he was the oldest brother, and he had to make a decision over their father. I can't remember how many kids were in the family, but he was the oldest one, so they just said, whatever you do, we'll go along with that. But he said he always wondered if he made the right decision because there was nothing in writing. So getting to what you were asking about Terry Schiavo, so she was on prolonged life support, 98 to 2005, and her husband said that she wouldn't want to be on prolonged life support. Her parents said that she would want to be on prolonged life support. So obviously, eventually, the husband won. She was taken off of, her feeding tube was removed, and then she ultimately passed away. If she had something in writing, and granted, she was really young when she collapsed and went into a coma. Most people don't think of having it in your 20s, but I think you really could have any of this stuff at any age. But if she had something in writing, then it would have been very clear for the family. Could have maybe saved a lot of heartache, expense, and time, and they would have known what to do. Does that answer your question about how to Terry Schiavo? Because nothing was in writing, so they didn't know whether or not she'd want to be maintained artificially. Her parents said yes, her husband said no. Makes sense?
I'll leave it there. That's.
All right, recognition. You can see an attorney get a living will, or as I just mentioned, you walk up to the hospital, or most healthcare which is the doctor's office, but most hospitals do give them out for free, so you can just get one there. Also, you can tell your loved ones what your wishes are, in addition to having it in writing. It's a conversation that most of your kids will not want to hear this, but it's good to have that conversation with them and say, these are my wishes. Also, you want to keep the original in a file. I'm all about keeping originals in safes, but also give a copy to your doctor so it's part of your medical record too. All right, so we're touching on designation of a healthcare surrogate. So this is where you appoint someone to make healthcare decisions for you. So in the state of Florida, you have 2 options. You can appoint that person to make decisions for you upon signing, or it can become effective if you lose your mental capacity. So it's only effective if something were to happen to you. Say you develop dementia, say you had a stroke and no longer capable of handling your own affairs, then your healthcare surrogate can then step in and make those decisions. Pretty much they have the same rights as you do to refuse treatment, that you would refuse or accept. I had one time a client who was funny. He said, absolutely do not have my daughter be my healthcare surrogate because she's pulling the plug as fast as she can. But he was a comedian, he was joking. All right, so advantages. So it's almost very similar to the living will, except for you're appointing that person. So you're ensuring that someone can make decisions about life-sustaining treatments if the individual is unable to make those decisions for themselves. You choose a representative to make decisions the way you would want the decisions to be made. It also just avoids confusion. I mentioned about the former pastor who had to make a decision for his father. I think maybe if his father had appointed him as a healthcare surrogate, he may have had a bit more confidence in his decision, because his father is saying, I trust you to make the decision, as opposed to the family saying, well, the older brother, you make the decision. Also, and I've had a lot of younger clients recently. A lot of my clients for the longest time were 75 plus, and now they're in their 40s, 50s, and they don't want their adult children to make decisions because they said they'll be too emotional. So they actually want someone outside of the family making those decisions for them. Which is new, it was in the past couple of years. All right, so those forms you can get, typically when you go to the hospital, the forms are together. So if you get the living will, that designation of a healthcare surrogate form is attached to it, so you just get them at the same time. Usually get the job done. Again, if you had a procedure, the designation of healthcare surrogate form may have been attached to it. So just check your paperwork and see if you have it. And when there is no designation of healthcare surrogate form, typically it goes to family. Like they look, so if you're married, they look at the spouse. If you don't have a spouse, they look at kids, maybe siblings. But there could be an issue where the family members may start fighting, and that's when a guardian may need to be appointed. So recommendation, you can see an attorney, or you may already have one, or you can just get the form at the hospital, and just discuss your wishes with your surrogate so that they know what it is. You have it in writing, you've also had a conversation with them, and you want to have the copy with your medical records. So we're moving on to a durable power of attorney. Is that with this?
What?
We're moving on to the durable power of attorney.
Sure.
Unless,
I was just gonna state one thing. It's sometimes painful to explain to family members all of these things, or you're not in the will, but you are. And it's a burden on you, but it's a much bigger burden on your children if you don't.
Yeah.
it's true.
And as a geriatric care manager, I spent a lot of my time doing mediation among the adult children because it hadn't been made clear. And so that's another gift you can give your kids, even though you're telling them you're not in the will, it is a gift. So you have to shoulder up to that.
Yeah, it is. To be honest with you, I've actually had some clients who would say, I don't want to talk about it with the kids, especially if they haven't been in contact with them. Like if there's no communication, then you can kind of bypass that. But if there is some communication, it's nice to have a conversation ahead of time.
Right.
So they're also not thinking there must be some mistake. Like I usually throw language in to say, I'm intentionally, these are my, Jane Smith's my daughter, but I'm intentionally not naming her as a beneficiary, which is not due to lack of love or affection. I usually throw that language in. And I've had people say, you can take it out. All right, durable power of attorney. So it's a legal document that enables an individual called the agent to pretty much step into your shoes and sign anything that you would sign. I highly recommend having one of these if you have someone that you trust in your life. It takes effect immediately upon signing. In the state of Florida, it used to have a spring power of attorney where it would only spring into life or into effect upon some sort of incapacity, but they did away with that back in 2010. And at the same time, they changed the law to create superpowers where you actually have to initial or sign your name next to the superpowers. And one of those superpowers is banking authority, and that's the authority that most people want their agent to have. Because if something happens to them, you want them to be able to access your finances so they can continue taking care of you and continue taking care of your business. Now, if you have it, and I don't have this here, but if you have a durable power of attorney that was signed before 2010, the law says it's actually still good. However, most banks, I find that a lot of, I shouldn't say banks, I should say institutions. A lot of institutions will say, we want you to get an updated, an updated durable power of attorney form. All right, so the difference between a durable power of attorney and a general power of attorney is a durable means that even if you lose your mental capacity, it's still effective, so it's still a valid document. Whereas a general power of attorney, if you lose your mental capacity, it's no longer good. You can no longer use the general power of attorney. I very rarely do general powers of attorney. I did one once, and it was because of a state issue. And so when I was preparing this, I was like, I've never done one. I thought, oh yeah, I have done one. Because they don't make any sense to me, because people do them oftentimes because they want to protect themselves so they do lose their capacity. So why do a general one if it's not effective after you lose your capacity?
Do you have to have a separate power of attorney for every potential transaction in this state?
No,
Just one.
this one, yeah. And so what some people do is they'll just have it on file someplace. So if you're doing a lot of transactions with a certain institution, you have it on file with the bank or whatever institution it is. Okay, the advantages. So the agent can sign documents on your behalf even if you lose your capacity. So they're a zero power attorney, they're no longer good if you pass away. A lot of people think they're still good even if you're deceased, but it only allows you to sign anything that they would sign. If they're deceased, they're not signing anything. So when someone passes away, they're no longer good. Also, even if there's no issue of capacity, they're convenient. So say someone's gonna be out of town and there's gonna be a closing on a house, you can use that durable power of attorney to sign that, sign the necessary, the agent can sign for you if you're gonna be out of town. So it doesn't just have to be loss of capacity. And even if loss of capacity is not an issue, I generally highly recommend getting a durable power of attorney for my client, to my clients, if they have someone they trust. If they don't have anyone they trust, then I don't recommend it.
Being an executor of a will is a big responsibility. I've been through 2 deaths in my family, and I know that the burden was placed on the siblings and also on someone else. What about hiring a young attorney to bear that burden for the family? What are your thoughts on that?
As the executive?
I think you could, but it might be an expense that you may not want.
That's taken out of the estate?
Yeah.
Okay.
I've had someone ask me if I wanted to do it, and I didn't want to do it because I also didn't think it was necessary.
Uh-huh.
So Florida, was it in Florida that you had
Yes.
this was? Okay. Yeah, I would decline doing it just because I think the state can save themselves some money. Because typically people, not that they're hostile, but if you hear the attorney's going to be the one making out, people all of a sudden get very friendly with each other and start working things out. So I think that if you just have one person that you can trust in the family, then they can do that. Some people do hire firms to do it, but again, that's a lot of money for the estate. I just don't think it makes sense to do it. But it's possible, you can do it.
Yeah, it knocks out that, you have somebody who's unbiased, that you trust to deliberate, and you have the panel or whatever, the table.
Yeah, I'm thinking
Everybody at the table at the same time.
it can get, depending on the type of estate. So say it was an estate that had a lot of debt to it.
Mm-hmm.
They're getting all that mail coming in. They're dealing, it's the different people that they have to deal with. I think it's going to get so expensive. But depending on whether or not maybe they don't mind the expense, if they want to try to keep the peace or they feel like having an attorney keeps the peace, then maybe it makes sense to do it if the fighting will cost more than the attorney fees for the attorney representative.
My sister, she lingered on forever. She won the lottery. And this is something that the whole family went through together, and her lawyer just now settled the estate, and it's been over 10 years.
Wow.
Wow. It'd be interesting to see how much the lawyers make from that.
Oh, I know.
And how much can
I used
go
to
on
work
the
for
family.
probate estate lawyers, and I know, and I told my sister, I said, you need to make sure, my other sister, you need to make sure that you know where the money's going, or ask for, a breakdown of where the money's going. And unfortunately, she was burdened with 2 other people in my family that had been the executor. She was the executor of the will for that,
Yeah,
so.
they could, so there's a formal accounting that can be done that breaks down where all the funds are going.
That's why I'm asking, I'm thinking along the lines of a lawyer.
No, you can definitely hire a lawyer. So I'm all about, if you can save money, I'm all about trying to save money for people. And usually, I mean, if you can use me less, you're saving money. So you use lawyers less, you're actually saving money. But if using a lawyer will minimize fighting, then that may actually save more money if the fighting's gonna cause more, more expenses to the estate. So
Right.
it just depends on the situation. I've never had anything that bad. The worst I had was the one I mentioned about could have been a month and was 2 years.
I'm willing to be, anybody in here is powerful of attorney, just, more you have in your bank, the more I'm willing to do.
What would be the motivation of an attorney to actually bring everything to
I'm willing to let Jerry use my name on his bank account.
Well, if they want to save, the family money,
But if they,
yeah.
do they have any fiduciary responsibility to bring things, efficiently to an end?
Well,
Can they be sued?
Not yet.
And maybe, I'm sure they can be, but I think it'd be very difficult to prove it, because what you do is you have an engagement letter that spells out so I have an engagement letter that spells out what I'm doing, and then I say, if you guys start fighting, or if I do anything beyond what we've agreed, then you can start charging more. So I think that'd be very difficult depending on the wording of the engagement letter.
So the durable power of attorney, you're given, like if I wrote one today, then those people could do all the things I do without my permission.
That's right.
That's what I'm worried about.
And so typically, longtime married spouses, I shouldn't make any assumptions, but
Yeah.
okay, you have it for each other, and then
Okay.
usually then would name a child. So if anything were to happen to the primary person, primary agent you name, then you can have a successor agent.
But if you name a child, the child can spend the money now.
Yeah, if they have it. So they actually have to have it.
They have to have access to it, the durable power of attorney gives them access.
No, they have to have the durable power of attorney to get
That's
the
what I
access.
mean.
Yeah.
You said put a child on it.
If
If we
you,
put a child on it now, that child has access to that money now.
yes. No, well, if you guys name each other.
Yeah.
No, you said and put a child on it.
No, I said name each other, then your child would be the successor. So if something were to happen to one of you, so say when you passed away or developed dementia, then your child would be the successor agent. So they wouldn't have it right now, they're only the successor agent. Does that make sense?
When I was 21, that would have been a great temptation, right? I mean, I can spend all my parents' money.
Well, so what you could
Didn't
do,
have enough money to spend.
so what you could do in a situation like that, if there's a concern, if you have multiple kids,
Yeah.
2 kids, okay. So what the brothers I mentioned before, with the designation of healthcare surrogate, where you have the father. So one brother was the agent in the durable power of attorney, but the other brother actually held the power of attorney. So whenever the agent wanted to use it, he had to go to the other brother. So it was like a checks and a balance. So they couldn't, one just couldn't just willy-nilly use it on his own. Does that make sense? Does that make sense? Okay.
You'd have to pay taxes on that money if you took it out of the bank, though, right?
What?
The kid, if they started abusing that and writing checks to themselves, they'd have to pay taxes on it.
Or with the
Do you
parents?
think, so if they abuse it, then they're gonna pay taxes on it? I
No,
don't-
they'd be obligated to pay taxes.
Yeah, it's income.
If they're abusing it, I doubt they're caring about income tax or something.
Can I just ask, or maybe you're coming to it, if you have a well, and then you attach things to it, like things have changed, is that legal?
Codicils.
Or
Yeah, you
you
do a
have to go in and
codicil.
redo a whole well? Can you admit, like maybe you bought something more, another hole or something else?
So typically in wills, you say, I'm leaving everything, so these are my beneficiaries, I'm leaving. So what I have in my wills, you have like a tangible assets, and you can say you're leaving a separate memorandum that's attached to this. So say you had a child that likes piano, you have a grand piano you want to leave to that child, you can attach that list to say grand piano, leave it to that child. Then you have a section that says the residue, which is just everything else. So that when you buy other stuff, you don't have to keep changing your will. But say you wanted to change the personal representative, that's the executive, what Florida calls the personal representative. and you just want to make that one change, you can do a codicil. And you're just saying that I'm changing my personal representative from Jane Smith to Tom Smith, and everything else is the same within the will. Does that make sense? All right, so the durable language is very important because, as I mentioned, if you lose your mental capacity and you don't have it, and you don't know what to say, and you don't have a durable power of attorney, then a guardianship is necessary. Because say you're in a situation where, do I have this? Yeah. So say you're in a situation where you don't have a durable power of attorney and you develop dementia or you're in a stroke. I actually just got an article recently about someone who had a stroke and he's no longer able to take care of himself. So his friends are going for a guardianship. Paperwork has to be filed with the court. And it can get the job done, but you're not the one choosing who you want to handle your affairs for you. Also, when you hear court, that's more expenses for your family and for you, because it's oftentimes coming out of your bank account, but coming out of your family's first. So again, it can be expensive. Also, it can create discontent amongst family because if you have two brothers and they both want to be the guardian, and they may fight over that. So what about the durable power forms you can obtain without an attorney? They could get the job done, but actually with something like this, highly recommend seeing an attorney to get a durable power of attorney, just because it can be, the consequences of not having one or not having it signed properly can be so dire. Because I actually dealt with this many years ago. I was talking with adult children, they were in their 50s, 60s, and their father had very advanced Alzheimer's. I don't think he could even really speak. And he was in his early 90s, the mom was in her 80s, but very healthy, and she took care of everything, and she suddenly passed away. So then you have dad who has very advanced Alzheimer's, who can't take care of himself, so he can't access his finances, his financial accounts at all. His mom's deceased, and there's no beneficiary's name there. Also, he's still alive, so the beneficiary doesn't matter. And they said, well, we have this durable power of attorney form, does it work? And this was after 2010, so they had the old form that didn't have the superpowers initial, because one of the banking powers is the powers that you have to initial, and it wasn't properly signed. It just had one witness. I don't think it was even notarized. So something like this, I highly recommend actually seeing an attorney to get. Oops, it's 11:51. Should I kind of speak there? We're good? Okay. All right, so again, I highly recommend getting it, and you can retain an attorney to get one for you. And in the state of Florida, copies are actually just as good as the original. So if you're concerned about having one child or one person named, you do that checks and balances that I mentioned, so that they have to work together.
So when you die, it dies, the durable power of attorney.
Correct. All right, so let's see. So if you currently have a durable power of attorney and you're uncertain about any of the powers, you can have an attorney review it. Also, family dynamics can change. So if you've done paperwork years ago and say you've had what I notice a lot of times is when someone gets married, sometimes that's when people can change. So if that's in the case, you want to just check your paperwork to see that you have named who you want to have named. Because we used to say, my old firm, this person can essentially go to Vegas and spend it all. That's what you guys are getting at. So there's a pre-need guardianship. I don't do many of these. The one time I've done it, it was because the woman was concerned about having a durable power of attorney. And what you're saying is you're naming someone to be my guardian for me if I lose my mental capacity. It's still a court process because you still have to submit a petition for incapacity with the court. And the judge may still say, I don't think this person meets the requirements to be your guardian. But it's a way to avoid doing a durable power of attorney. Now, this lady was not married, no children. She trusted this person, but she still said, I don't want to give any powers away right now. And I said, if the person has the power of attorney, that's, you're giving someone authority to act on your behalf. She said, I only want them to have that authority if I lose my mental capacity. And before, when we had a spring power of attorney, durable power of attorney, it would have worked. But since we don't have that, then this was her alternative. Okay, trust. I touch on trust really quickly because I actually don't do too many trusts. When I go into the cons of trust, you'll see why. So it's a vehicle for a person to put their assets into, and you have a trustee that manages those assets for you. Then you can name beneficiaries for you. And you can name beneficiaries to the trust who benefit from the trust assets. And this is a way where you can avoid probate. That's that whole court process. So say you have a bunch of assets, so your house, your financial accounts, and you name you fund the trust by putting all your assets in the trust. If you pass away, you have a successor trustee and they continue on as managing the trust for you. And there's several different types of trusts. There's a revocable trust, irrevocable trust. You mentioned a living trust. Usually when we were talking about living will, usually living trust goes with a revocable living trust, which is different than the living will, which is the health. So in pros, like I mentioned, you avoid probate, you can have greater control of your assets, and you can have a trustee or successor trustee who can manage the assets in case of incapacity. Now the cons, many people find them very confusing. I've had clients where before me, they got a trust that was like this thick, and they come to like, I have this thing, I don't know what to do with it. And it can be very expensive, and there are usually less expensive ways and simpler ways to accomplish the same goals. So for example, I was talking to another attorney who was met with a lady who, she owned a mobile home, but she didn't own the land under the mobile home, just the mobile home. And she had a checking account, I think that had maybe $10,000 in it. And she got one of those very complicated trusts that was like this thick, had no idea what to do with it. And she was just leaving everything to her one son. She was not married and she had one son. And so the attorney said, well, why did you get this? And she said, well, I don't know, that's what the attorney told me I needed to get. Whereas in a situation like that, when you have a bank account, just have one son, just name your son as beneficiary, so when you pass away, it goes to your son. And as for the mobile home, in the state of Florida, vehicles and the mobile home doesn't actually go through probate. You go to the tag agency or the tax collector and they can just transfer it there, but you actually do not have to go through a court process to transfer it. So I find that most of my clients can actually achieve their goals in simpler ways, less expensive ways than getting a trust.
Can I ask a question there? I understand that trusts are really good for people who have extremely complicated financial assets. Is that correct?
So if you're a certain wealth, certain amount,
Okay.
and so far in my practice, 99.9% of my clients have not been in that. So I haven't had to deal with that. When I worked in my old firm, there was a couple people did, and I was only on the periphery. But if you are very wealthy, wealth of a certain amount, or if you have certain instructions, like I have 3 kids, I want money to this child's supposed to pay this child. I think a trust works for that. So that goes into what you're saying about being complicated. So it can help in those situations.
I always heard that trusts always avoid probate, so therefore you should get a trust. Is that correct or not?
Trusts do avoid probate, but most people don't fund their trust and put everything in the trust. I know so many people, they come in, and so I just did, actually not just, but recently, I did a probate for a woman. She has a trust. Everything they have under the sun is in the trust, except for one account that $500,000 that they forgot to put in the trust. And they just named the estate to it. And I think that might have been a mistake, because I've seen that before where they say the estate of such and such instead of the trust, the trustee of the trust. So they do avoid probate if they're used properly.
I have a question. I heard there was somebody on TV talking about this person had his kids named in a trust, and the house was in a trust. They decided they wanted to sell the house. So because of the particular trust they had, all the kids would have to pay taxes on the profits of the house. Does that make sense? Yeah, it was something.
Was that Florida?
It was what? No, it was in Massachusetts.
Okay.
But so they bought the house for like $30,000 it's worth. So when they sold the house, everybody had to agree, but then they all had to pay taxes on, I don't know what kind of a trust it was, but they would have to pay taxes on the profits of that
On the
house.
capital gain?
Yeah.
That's probably,
And I would think usually it's like a stepped-up basis, so you don't pay from the time when they got it, you pay from like when the person passed away, so, because that's a lot of money.
Yeah, but whatever it was, they had to pay taxes on whatever the profit was.
It could be, but I'm not sure.
Yeah.
I can't really speak on that. Okay.
It's good we're getting 86,000 new IRS agents, huh?
I know, yeah.
They're going to make the most.
Oh, 87?
Oh, I'm sorry, I missed it.
Sorry.
So,
So, yeah, my dad had a trust. He obviously didn't need it, but there were 8 kids and that. And I was the executor, so I gave everything he wanted. But he put in a timeshare that he had. And I heard, so I've still been paying the silly maintenance fees. It's in California for like, I don't know, 10, 12 years now. Can I just let that go, or do I have to keep paying on that under the trust, or is that a legal thing? I don't know.
So I would say, depending on the language of the trust, like whether or not you have to get permission to do certain things within the trust. I would think most people would say they, get rid of it. But I would check and see how you can legally get rid of it, because I think they're gonna continue hounding you if you just stop paying the maintenance fee. The people are still gonna keep coming after you. But I would see if the trust allows that. Like, what is the trust? Does it grant you the authority to act by yourself to do these things, or do you need to get, the consent? Or
My siblings don't want it. Yeah, they don't have nothing to do with it. So,
so you may still need to. So the trust may still say you have to do that.
to just get permission, then you have the trust. I would have to go back to his original attorney to do that, the one that he had.
Probably. Well, if you wanted to, I would say probably not. But if the original attorney was the one who prepared it, it may be easier if you go back to the original attorney to do that.
I mean, I could just tell the maintenance people at the.
Or see if they'll take it back. Just see if they'll take it back from you.
Okay.
All right. So conclusion. Okay. Oh, sorry. I missed the wrap it up. Okay. So conclusion. So I've covered the basics, but if you want to learn more about these documents, or if you need any of these documents, I strongly urge you to retain an attorney. It's important that you get your affairs in order now. And you want to do it now when you're not in a stressful situation, where you're not dealing with illness, when, it's when you have the time to think about it, because we don't make decisions the same when we're stressed than when we're not stressed. So the benefits of addressing these matters now will have a lasting impact on your loved ones, on your peace of mind, as well as on your bank account. So thank you guys for listening. Thank you.